All rise. Okay, please be seated. Good afternoon. I will note for the purposes of the record that all 12 plus our 3 are present in the courtroom. During the lunch recess, were there any violations of the court's admonitions?
No.
Were there any deliberations?
No.
Any discussions of the evidence?
No.
Any expression of any opinions or belief?
No.
Any consultation of any outside sources?
No.
Any independent research?
No.
Any violations whatsoever?
No.
Are the 15 of you ready to proceed?
Yes.
As I had told you earlier, you had heard all of the evidence that you were going to hear in the case. Likewise, you have heard the closing arguments of the attorneys. What is left is for me to give you your jury charge and your jury instructions. Understand that this is lengthy. The law requires that I read it to you, but understand that the entire typed instruction will be given to you along with the evidence that was submitted in this case for you to take back to the jury room for your consideration. The defendant, Sean Patrick Foley, is charged in the indictment with the crime of premeditated first-degree murder. The offense necessarily includes the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence in this case has been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but consider each one in light of and in harmony with the others. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural. Whenever the word he is used in the instructions, you may also consider applying equally to a woman or an entity such as a corporation, which is not applicable here. The indictment in this case is the formal written accusation charging the defendant with the crime. It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would have been no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matter is to be treated as though you have never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. The law presumes that the defendant is innocent of the charge against him. This presumption remains with the defendant throughout every stage of this trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of this case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof that is necessary to constitute the offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. The burden is upon the state to prove by preponderance of evidence that this offense was committed in Blount County, Tennessee. Proof by preponderance of the evidence means the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance evidence that this offense was commenced or consummated in Blount County, Tennessee, then you must return a verdict of not guilty. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim. And number two, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And number three, the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion to be capable of premeditation. If the design to kill was formed through premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you have a reasonable doubt as to the defendant's guilt of first-degree premeditated murder as charged in this presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser-included offense. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim. And number two, the defendant acted knowingly. Knowingly means that the person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has previously been defined in the instructions on premeditated first-degree murder. Refer to that definition. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you have reasonable doubt as to the defendant's guilt of second-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and you then shall proceed to determine his guilt or innocence on voluntary manslaughter, a lesser included. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim. And number two, that the defendant acted intentionally or knowingly. And number three, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Again, the distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in a rational manner. Knowingly and intentionally have previously been defined for you in the instructions on premeditated first-degree murder and second-degree murder. Refer to those definitions. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, the defendant killed the alleged victim. And number two, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined for you in these instructions. Refer to those definitions. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant's conduct resulted in the death of the alleged victim, and number 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have all been previously defined for you in these instructions, and you should refer to those here. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense. Self-defense. Included in the defendant's plea of not guilty is his plea of self-defense. If a defendant was in a place where he or she had a right to be, he or she have a right to threaten or use force against the deceased or alleged victim when and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use or attempted use of unlawful force. The defendant would also have no duty to retreat before threatening or using force. If a defendant was in a place where he had a right to be, he would also have a right to threaten or use force intended or likely to cause death or serious bodily injury if the defendant had a reasonable belief that there was an imminent danger of death or serious bodily injury, the danger creating the belief of imminent death or serious bodily injury was real or honestly believed to be real at the time, and the belief of the danger was founded upon reasonable grounds. The defendant would also have no duty to retreat before threatening or using force likely to cause death or serious bodily injury. In determining whether the defendant's use of force in defending himself was reasonable, you may consider not only his use of force, but also all the facts and circumstances surrounding and leading up to it. Factors to consider in deciding whether there are reasonable grounds for the defendant to fear death or serious bodily injury from the deceased include but are not limited to any previous threats of the deceased made known to the victim, the character of the deceased for violence when known to the defendant, the animosity of the deceased for the defendant as revealed to the defendant by previous acts and words of the deceased, and the manner in which the parties were armed and their relative strengths and sizes. If proof was offered by the defendant of a character of the deceased to show that the deceased was the first aggressor, and proof was then offered by the state of a trait character of the defendant to show that the defendant was the first aggressor, such proof offered by the state for that purpose can only be considered by you for the purpose of its effect, if any, in rebutting the defense proof that the deceased was the first aggressor and that therefore the defendant acted in self-defense or defense of a third person. It cannot be considered by you as evidence of his predisposition to commit the offense for which he is now on trial. The threat or use of force against the deceased or alleged victim would not have been justified if the defendant provoked the deceased or alleged victim's use or attempted use of unlawful force, unless the defendant abandoned the encounter or clearly communicated to the deceased or alleged victim with the intent to do so, and the deceased or alleged victim nevertheless continued or attempted to use unlawful force against the defendant. Force means compulsion by the use of physical power or violence. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully pointing a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Imminent means near at hand or at the point of happening. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. To convict the defendant, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense, and if all from the facts and circumstances you find the defendant acted in self-defense, or if you have a reasonable doubt as to whether the defendant acted in self-defense, you must find him not guilty. Defense of a third person. Included in the defendant's plea of not guilty is his plea of defense of a third person. A person is justified in threatening or using force against another to protect a third person if, number one, under the circumstances as the person reasonably believes them to be, the person would be justified under the principles which apply to self-defense in threatening or using force to protect against the use or attempted use of unlawful force reasonably believed to be threatening the third person sought to be protected, and number two, the person reasonably believes and the intervention is immediately necessary to protect the third person. Refer to the court's prior instruction on self-defense here. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in defense of a third person. If, from all the facts and circumstances, you find the defendant acted in defense of a third person, or if you have reasonable doubt as to whether the defendant acted in defense of a third person, you must find him not guilty. For deliberation, the order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt as to the defendant's guilt of that offense, you shall only then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that indictment. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in the indictment, you shall return a verdict of not guilty. Expert witness. During the trial, you heard the expert witness testimony of Dr. Chris Lockmuller, who was described to you as an expert in the field of forensic pathology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of collateral facts and circumstances which do not directly prove the fact in issue, but from which the fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe that it deserves. Credibility of witnesses. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may be helpful to ask yourself these questions. Number one, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought that they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important in how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The defendant, having testified in his own behalf, his credibility is determined by the same rules by which the credibility of other witnesses is determined, and you will give his testimony such weight as you think it may be entitled. Impeachment of a witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken back to the jury room, proof of such inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantial evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Identity. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of the proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances of this case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it is your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof of the case, you should return a verdict of not guilty. Prior statement of the defendant. The court instructs you that if there is evidence of an oral or written statement given by the defendant in this case You may take it into consideration with all the other facts and circumstances proven in the case. In considering the statement, it is for you, the jury, to say what weight you will give the statement. You may believe any part of the statement or disbelieve any part of the statement, and you may believe the whole statement or disbelieve it in its entirety. Confession or admission against interest. Evidence has been introduced in this trial of a statement or statements by the defendant made outside of the trial to show a confession or an admission against interest. A confession is a statement by the defendant that he committed the crime charged. An admission against interest is a statement by the defendant which acknowledges the existence of or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. And so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judges of what weight should be given that statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Notes. Some of you have taken notes during the trial. Once you retire to the jury room, you may refer to your notes, but only to refresh your own memory of the witness's testimony. You are free to discuss the testimony of the witnesses with your fellow jurors, but each of you must rely on your own individual memory as to what a witness did or did not say. You should not view your notes as authoritative records or consider them as a transcript of the testimony. Your notes should carry no more weight than the unrecorded recollection of another juror. Cause of death. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of a death is that cause which in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as the proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an intervening act or omission of the deceased or another which the defendant, in the exercise of ordinary care, could not have reasonably have anticipated as likely to happen. However, if the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, the cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. If you find that the defendant acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find him not guilty. Deliberations. Members of the jury, we talked about this during jury selection, but for the purposes of these formal instructions, I'm going to instruct you as follows. Some of you may have been exposed to pretrial publicity in this case. You can consider no information in your reaching of your verdict other than the evidence that you hear in the courtroom. It would be further impermissible for you to mention during your deliberations to any other juror any information that you recall reading, hearing, or seeing in the media or otherwise related to this case other than what you hear or see in the courtroom. This case must be decided solely upon the evidence that you have heard in this courtroom. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, computer, internet service, text or instant messaging service, internet chat room, blog, or website, including but not limited to Facebook, Instagram, LinkedIn, YouTube, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until you return your verdict and the trial has concluded. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it was erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. You can have no prejudice or sympathy, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find that the state has not proven the defendant's guilt beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt of the charged offense and the lesser included offenses, then your verdict must be not guilty. You will be provided with a verdict form which lists all possible verdicts in this case. The jury will complete the verdict form and your foreperson will sign it. The verdict form which you will receive reads as follows. This will be your verdict form. It's titled State v. Sean Patrick Foley, and it goes in the following order. We, the jury, find the defendant Sean Patrick Foley, and it's listed A through F. As I have previously told you in these jury instructions, you must consider them in order. So you must first reach a unanimous decision as to the first before you can move on. And so there's a jury instruction on that, and I'll ask you to refer back to that as you deliberate. When you retire to the jury room, you must select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and the foreperson will deliver it to the court. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them. And I have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the presentment in this case will be handed to you together with the charge, the exhibits in the case, and the verdict form. If you have a question during your deliberations and you need further instructions, please print your question on a sheet of paper, knock on the door of the jury room, and give the question to a court officer, but do not in any way discuss the question with the court officer. I will read your question. I may call you back into the courtroom to try to help you. Please understand that I can only answer questions about the law, and I cannot answer questions about the evidence. Please keep the door to the jury room locked until the foreperson knocks on the door to present you with a question. There'll be an officer outside the door at all times. If you have any other issues or you need anything, just please knock on the door and we'll try to assist you in whichever way that we can. Okay. Do either of you have anything else?
No, Your Honor. Not at this time, Judge.
Okay. We'll ask, are the 12 members seated at the jury ready to deliberate?
Yes.
And all of you are prepared to proceed?
Yes.
Then I'm going to ask our 3 alternates, do you have any personal effects in the jury room? None of you do? Okay, then I'm going to ask that you just remain here until I send them back. Okay? Ladies and gentlemen, at this time, after 3 days of telling you that you can't talk about the case, I'm telling you that you are now free to begin your deliberations. If you need anything, please let us know. All rise. Okay, please be seated. Gentlemen, your term of your jury service has now ended. as alternate, and obviously we used an alternate in this case, so more often than not we need them, whether sickness or other issues apply. So thank you very much for your service. This does conclude not only this term, but you can be excused for the next 2 years should you choose to do so. If anyone tries to speak to you about the case, you do not have to speak to anyone. I would ask that you refrain from giving any comment until after a verdict is reached by your other jurors. In the meantime, if you could please leave your juror badges on the bench behind you. And give me just a minute. Okay, if you could please go with Officer McNeil. All right. Thank you, gentlemen.
Thank you.
Okay. I need cell phone numbers from everybody. If y'all put any contact numbers on a piece of paper. Ms. Graves, if you want to get that from them. And we're in recess for the jury to deliberate. Thank you.
Sure.
I'm not sure they have a way to play the recordings.
They don't have any of the exhibits right now.
What?
They don't have any of the exhibits.
Right, we're still working on. Let me sign this and give this to him, and then I'll move to that. Give me just a second. I think at this point we need to.